Smart business people are increasingly asking their design and construction attorneys, why do we pay so much to prepare for trials which seldom occur? And this is something that I heard a couple years ago. It hit me like a bolt of lightning, and it's really changed the way that I practice law. Because I think that empirical evidence is quite clear that most design and construction disputes settle short of a trial by jury or an arbitration hearing where the arbitrators take evidence and pick a winner and a loser. And I attribute this question to my former law partner and mentor at Schiff Hardin, Paul Lurie, who's driven home to me the fact that increasingly smart business people are wondering what's the virtue of spending quite so much money to take in all this evidence, to gather these documents, to take all these depositions and do all this work to get ready for trials which seldom occur. And I think that increasingly this question is going to be asked by our clients because it really is particularly important in this new era that we find ourselves in. Certainly artificial intelligence has new applications, and it's changing the way that we live and we do business every day. In the last few months, ChatGPT has been all that people have talked about. And in this new era, I think it's clear that information and the ability to get your hands on information is abundant. And it's abundant not just for lawyers, but for our clients too. You know, this lawyers guild, this idea that's prevailed for centuries, where lawyers are gatekeepers of this information. I think it's changing. When I started my law practice more than 20 years ago, it was the case that a lot of the information that people would need to decide whether to resolve a design or construction dispute was locked away in a law library. It was in paper format, and you couldn't even step into the library and get past the security guards unless you had this law practice credential, unless you're a part of the guild. And I just don't think that that's the case anymore. And because of this, and because so few design and construction cases actually go to trial, so many of them, almost all of them, are settled, but they are settled too late and after too much inconvenience or expense. I think that we're going to have to prepare as design and construction attorneys to answer hard questions from our clients. You know, I think that we are nearing the end of this idea of unlimited hourly billing, that's not capped, in order to take all these depositions and do all this work, which gets us ready for trial and then eventually doesn't go anywhere. Because, other industries have figured out, how to cap fees. I mean, consultants and other industries have figured this out decades ago. And increasingly, I think that major clients who are in charge of substantial commercial destruction disputes are going to want to fix legal fees so that the lawyers are rewarded for spending fewer hours on the resolution process. And this is one of the reasons why I think this question, why do we pay so much to prepare for trials which seldom occur, is so important. And it's one of the reasons why I think that guided choice dispute resolution, which is, one kind of mediation, is going to become so important in the next few years. And certainly it's my belief that at least when it comes to design and construction disputes, I wouldn't necessarily apply this to every kind of dispute, but at least when it comes to civil litigation as a means of resolving design and construction disputes, I'd argue that it's nothing more than the most inefficient means of exchanging information that's ever been devised by mankind. This American style adversarial legal system, which, leaves no stone unturned, was important in the past. I don't know that it's quite so important anymore now that it's just the case that most of these disputes get resolved on the courthouse steps after too much expense and too much inconvenience for our clients. I think it's true, based on having litigated for 20 years, that most litigation attorneys assume that substantial adversarial litigation, discovery, and motion practice is necessary. And it's necessary because they're preparing for trial. But I think that that's not really what we have to focus on. I think we have to focus on how much information do our clients need to be able to make a business decision to either settle or not. In other words, how much information do they need in order to make a strategic determination of what's in their best interests? And it's certainly not the same amount of information that is necessary to go to trial. It's not all the information. And I think increasingly, it's worth remembering that very little happens in discovery that's magical. I mean, occasionally that's not true. There's a really important deposition or admission, and occasionally in the litigation process, you'll have a dispositive motion or something like that. But most design and construction disputes, in my view of having litigated for 20 years, there's a disproportionate spend and inconvenience associated with this adversarial discovery and motion practice than what you get out of it, And so I'd say there's really very little that happens in this process that's magic, certainly on most disputes. And so I believe, and this is something that Paul Lurie has preached for years, that the settlement process should begin before our clients begin to incur the major expenses associated with this adversarial litigation, discovery, and motion practice. And I think that we're going to get asked hard questions in the next years and decades from our design and construction clients, and it's because of this very high rate, near to 100%, of settlement in both litigation and arbitration, short of trial. I think clients are going to ask a number of questions, and one I think is what value do we get from paying you, our design and construction lawyer, to prepare a case for binding dispute resolution using these time-consuming adversarial tools if the case is just going to settle on the courthouse steps anyway? I think that if we have a good answer to the first question, then I think our clients are going to say something along the lines of, okay, well, why didn't you also initially discuss with us options for pursuing settlement processes that would run in parallel with your trial preparation and yet avoid most of the significant costs? Because I think that clients increasingly want to hear, even if they're convinced there's a dispositive motion we have to pursue, or we've got to take this deposition, okay, so there's a good reason why we've got to do this substantial adversarial litigation, discovery, and motion practice that's expensive and time-consuming and inconvenient, fine. If we have to do that, why not pursue in parallel some path that might lead to a settlement, which might lead to early, cost-efficient dispute resolution? And, if you're able to answer these questions, I still think that design and construction clients, the principals who own design and construction firms and, perhaps in-house attorneys, are going to say, why is it that companies like us, which use your competition, competitor attorneys, how come they get the information that they need to decide whether to change positions, to decide whether to change their position on settlement more quickly and with less expense than us? Why is it that we, have to spend all this money a couple of years later, we hear, okay, now the case has matured to the point of settlement? And certainly if I'm the client, these are the questions that I'm asking, and potentially firing a lot of design and construction attorneys, because again, increasingly, I think smart business people are asking, why do we pay so much to prepare for trials which seldom occur?